What's up everyone? Welcome to the Legal Mix. My name is Dimmy and today we're discussing trademarks, protecting your brand. The purpose of a trademark is to protect a company's brand, and it does so in two ways. First, it prevents customer confusion. A trademark helps a customer identify a particular company's products or services and avoids them purchasing another company's products or services. Two, it protects a trademark owner's reputation. It provides a trademark owner legal recourse against a competitor who sells products or services under a similar name. For example, Sue is a well-known mobile DJ in her market. She operates and has trademarked the name DJ Sue Everyone. A competitor, Karen, starts a company using the name DJ Sue One. Sue, because she trademarked her name, now has legal recourse against Karen because there's the potential of confusion amongst consumers. Think about it. In this industry, your brand is everything. You spend a lot of time and effort in growing, building, and developing your brand. So the last thing you would want is for consumers to confuse your brand with that of another company. So what law governs trademarks? Trademarks are governed by both state and federal law, but for our purposes, we'll focus on the federal Lanham Act, which provides broader protections for trademark owners. The level of protection that a trademark offers depends on how distinct it is. Its strength is relative to how unique the trademark is. Trademarks are broken down into four categories. The first category provides the most protection, and the last category provides the least. The first category is fanciful and arbitrary marks. They're two different things, so let's look at them separately. An arbitrary mark has a meaning that's unrelated to the products or services on which it's used. For example, tractor typically means a type of motor vehicle. This is a meaning which is unrelated to DJ software. Thus, when Native Instruments uses the trademark tractor to refer to its DJ software, this is an arbitrary mark. A fanciful mark is a made-up word which is associated solely with the underlying product. For example, Serato is a made-up word which is associated only with the DJ software. Arbitrary and fanciful marks are inherently distinctive and as such are afforded the highest amount of protection under trademark law. The second category is suggestive marks. These imply the nature of the underlying products or services. They require for the consumers to make a mental leap to associate the word with the product or service. For example, Beats implies a musical beat. As such, when Beats Headphones uses the trademark, this is a suggestive mark. While these are inherently distinctive, suggestive marks are afforded less protection than arbitrary and fanciful marks. The next category is descriptive marks, which, rather than suggest, actually describe a quality or characteristic of the product or service. For example, record box describes a feature of a DJ software used to organize music, sort of like a record box for records. Because these marks are not inherently distinctive, they're given trademark protection only if they've acquired secondary meaning. Secondary meaning is acquired by descriptive marks when the public associates the mark with the company rather than the underlying product. So for example, the DJ public associates rekordbox with the rekordbox software rather than an actual box of records. The last category is generic marks, and these describe the general category to which a product or service belongs to. Thus, it's not inherently distinctive, and therefore, generic marks are not granted any trademark protection. For example, the word turntable describes an entire category of products, and therefore it cannot be trademarked. So how do you obtain the rights to a trademark? There are two ways under federal law. The first is to use the mark in commerce, and the second is to be the first one to file with the U.S. Patent and Trademark Office. While there are several benefits to registering a trademark, there are three very important ones that you should consider. First, registration provides the presumption of legal ownership of the trademark. 2, it provides public notice of ownership. 3, it provides protection throughout the whole United States, whereas being the first to use a mark in commerce is only limited to where the trademark owner operates. At this point, I should mention, although I've talked about being the first to use a mark in commerce, you can also register a trademark with the bona fide intention to use the mark in commerce. The first step towards registering a trademark is to check, has it already been registered? The way to do so is to go on the U.S. Patent and Trademarks Office website and search their database. In order to register a trademark, you have to submit an application. You can do it yourself, or you can hire somebody else to do it for you. If you decide to do it yourself, this is how you do it. To register a trademark yourself, you will need to go on the U.S. Patent and Trademark Office's website and create a profile. From there, you need to file an application. The application will specify the basis, whether you're already using the trademark in commerce or whether you intend to use it. Generally, the application will contain 3 elements. 1, a drawing of the mark. 2, identification of the goods or services associated with the mark. And 3, a specimen showing the mark is actually used in U.S. commerce with goods or services. After filing, the application will be reviewed by an examiner who will determine if it complies with trademark laws and whether it conflicts with prior registrations or applications. Once the examiner approves the application, it will be published in the official gazette, which will start a 30-day period within which a third party may file an opposition to the application. After this period closes, if no one successfully opposes the application, then the Patent Office will register the trademark and issue a certificate of registration. The registration will remain valid as long as the mark continues to be used in commerce and may be renewed every 10 years. Once a trademark has been registered, its owner can enforce their rights in several ways. They can send cease and desist letters, they can file a lawsuit, and also they can request that social media platforms remove infringing material. All of the major social media platforms, Facebook, Twitter, Instagram, YouTube, have ways in which trademark owners can report infringing material and have it removed. As I said earlier, in this industry, your brand is everything. Therefore, you should do everything possible to protect your brand, including registering your trademark. Thank you for tuning in, and I'll see you next time here on The Legal Mix.